Now we're going to get ready for our second talk in this session, and this is by Professor Lorenzo Cavalaglio, I hope I pronounced that properly, from the Pontifical University of the Lateran, who's going to speak about law and legal professions, the experience of teaching notarial law in a law school.
Thank you. In my presentation, I will deal with the difficulties that law schools encounter in civil law countries in preparing students to legal professions, analyzing mainly the situation in France and Italy, and finally considering the experience of my law school. Nowadays, we have to say that many other critiques move to the way in which law schools prepare to legal professions, and actually, even if for the most of students, the activities of attorney, solicitor, judge, notary will represent a probable future after the law school, their preparation is increasingly described as unfit. And we have to say, actually, that the problem of teaching methods in law schools is not so recent. Almost 50 years ago, John Merriman said that most of the professors of civil law universities were unconcerned about teaching objectives and methods. On the contrary, in the US, one could find a continuous self-searching about the teaching. Other scholars remarked that the teaching that was the real heart of legal science in Middle Age universities at the beginning of European legal tradition had become by then the Cinderella of research. Since 1975, of course, many studies appeared about the necessity of new approaches in teaching, both in France and Italy, and a new science of formation spread in legal academy. Nevertheless, the hiatus between academic formation and legal professions is still evident. One reason is that in civil law countries, courses normally consist of a general and often theoretical presentation of the rules governing a specific field of law, private law, criminal law, civil procedure, and so on. The teaching of the subject starts from the general principles, often common to several courses, then introduces some hints about the historical evolution of the field, and dedicates most of the time to the analysis of the statutes regulating the different partitions. In many cases, a peculiar attention is given in books and in the classes to the cases and the role of courts, so that many students, even in the best schools, end their studies with no possibility of studying or reading a contract, a complaint, the bylaws of a company, let alone writing a clause. In France, the TD, Travaux Dirigés, tried to represent the practical side of a course for a more restricted group of students, but they are mostly dedicated to explain the subjects with direct reference to statutes or judicial cases, and moreover, they are taught by people who are at the beginning of their academic career, and obviously they model their classes on the example of the main professor, whose path is followed step by step. Similar are the seminars, whose attendance is not mandatory, that are traditionally proposed by Italian universities, in which assistant professors teach specific parts of the main courses in a more detailed way than professors can do in their classes, and assign some works dealing with the subjects treated. In short, this fragmentation of courses actually does not affect the way of teaching, that remains preeminently theoretical. After the degree, the following steps are different in Italy and France. In Italy, the preparation to legal professions is substantially entrusted to schools, to private schools. The students can, and be aware, they do not have to attend after having completed the 5 years of law school and having obtained their GED, so that there are schools for becoming judge, lawyer, or notary. The exams granting access to legal professions are organized yearly by the Minister of Justice and are very difficult. And so that even if those schools should prepare to the exercise of profession, the risk is that they offer just technical instructions for passing those exams. Indeed, courses in these schools, or most of them, are nowadays given with few references, both to the general principles of law and to the practical matters, because of the strong competition among these private institutions and the aims of students. The latter think that studying subjects that they are supposed to know because of the 5 years of law school or questions dealing with their future profession is not useful for the exams. The former, the schools, adapt their programs to the needs and demands of their potential clients. The consequence is a significant fall in the competence of the legal professions. The legal professionals often lack elementary knowledges in the main fields of law. In France, on the contrary, after the first 3 years in which law schools offer general courses to the students, often very general, the attendance of 2 years of Master 1 and Master 2 actually, is mandatory in order to become a legal professional. Then after these 5 years of study, there are specific schools for preparation to the different professions in which theory and practical training, stage, are carefully mixed and verified in different steps. As a matter of fact, this step-by-step approach is surely preferable to the Italian all-or-nothing method, based on a 3-day written exam that may be individually prepared and doesn't take in consideration the contents of the traineeship, that is mandatory even if it is not so carefully verified. Nevertheless, the characteristics of French approach substantially make students decide their path after only 3 years of legal studies. It is possible to change one's mind, of course, but it is difficult to modify and adapt the preparation to a different career. The comparative advantage of Italian system in this perspective consists in the possibility of reserving your definitive choice up to the final exam, and even beyond if you are able to calibrate your post-degree studies. That is not impossible because the exams granting access to legal professions are very theoretical in Italy. But that is actually the question, as we said before, a theoretical exam. In the Pontifical University of Lateran, in my School of Law, we try to follow a different path. The idea is allowing all students to know the actual matters that legal professionals, and not only notaries indeed, have every day to cope with, creating a notarial law course in which subjects are presented according to a totally different approach. That is to say, analyzing real contracts, bylaws, the way in which public registers and courts actually operate. And in doing so, we divide the subjects in 3 different fields: private law, commercial law, and administrative law. And in each branch, practical cases are taken into consideration, examining real acts from a theoretical perspective, analyzing the general questions implied by the situation, but from a practical point of view. That is to say, making students playing the role of an actual professional who has to face the questions her clients ask. So that a will, for example, is the occasion for revising the issues of the capacity of the testator, of the limits to its freedom of the disposition, of the possible content of legacies, devises, and bequests. But the illustration of these legal institutions is made through the analysis of the situation preceding and following the making of the will itself, the needs and aims of the testator, the delicacy of the legal advice in this field, the difficulties deriving from a will, the legal actions that heirs can bring to protect their interests. All these questions are explained and analyzed in order to let students understand legal institutions as a whole, helping them to go beyond the partitions of different subjects. For example, the exam of a minute of meeting of a company's shareholders. That is very peculiar because it calls into questions not only the summa divisio between private and commercial law in Italy, if the code sums up the two fields, differently from France, for example, the partitions of the subjects and of the academic teaching, of course, is still very marked between private and commercial law. But especially we challenge the intended ignorance of economical reasons lying under the decisions of a company. so that corporate law institutions are verified in relation to the clauses of the bylaws, of the meaning of the authorized share capital, and the discipline of its legal protections, with concrete examples of market operations such as mergers and acquisitions, reductions and capital, and so on. And so, for the purchase agreements, that imply not only the classical problems of the transfer of ownership, conditions, warranties, the interpretation of clauses, but also the questions of the inscription in public registers, the role of notaries in ascertaining the title before the deed, the validity of the deed itself, themselves, and so on. Students have the possibility of analyzing and try to draft real agreements, starting from the moment in which a moot client enters the notarial office and says, for example, I want to buy a house. They're invited to play the role of the seller and of the purchaser and of the notary too, not only before and during the execution of the deed, but even after it, trying to face the questions arising from errors in inscribing titles in public registers or from the presence of liens and encumbrances. Moreover, the complex system of administrative regulations about property is investigated, so that we say that the critiques about the way in which law schools prepare students to legal professions are not new. At the beginning of the 20th century, one of the most famous Italian scholars, Vittorio Scialoia, already complained about the insufficient preparation of candidates to the exams for the admission to the bar, or for becoming judges or notaries, and he criticized strongly the still prevalent didactic method of civil law schools, the so-called lessons ex cathedra, that he defined homilies. Actually, many are the defects of the traditional method of teaching, but they can mostly be corrected, I think, with a partial adoption of the Socratic method, actively involving students in the solution of real-life problems. That is a way of making them actors and not only spectators of their own processes of living law, avoiding both the transformation of law schools in professional institutes and the partition in students according to their preferences that are inherently premature because they cannot know the reality of legal work. Moreover, it contributes to the formation of jurists, not only potential actors of job market. The notarial law of our law school tries to follow these rules, not limiting the classes to the specific point of view of notaries, as I said, but adopting an interdisciplinary method that involves students in examining questions and matters according to the perspective of a legal counselor, an attorney, a judge, obviously starting from the general principles that they learned in general courses of the first years and considering them from a practical point of view. In conclusion, as Felix Frankfurter said, law and the lawyers are what the law schools make them. An exclusively dogmatic approach is not useful to prepare students for the profession, but at the same time, I think it is necessary not to divide students into different specializations too early, because they're not linked to the whole corpus of their studies, and they're contrary to the cultural aim of a law school that should never be a merely professional traineeship. As Raymond Saleil said in the 20th century, the intellectual, scientific, and ethical education of the new generations is a peculiar responsibility of professors, and nous ne pouvons nous y soustraire. That is to say, we cannot avoid it. Thank you.
Thank you very much indeed. So let's throw that out for students, for questions rather. Question number one, how did the students respond to the way your school is teaching law? That's from Esther Ellings again.
Well, they're very interested because they are not accustomed to this way of teaching and learning. And I have to say, many students tried after our courses to become notaries, but not only. Many students who follow these courses want to become lawyers or judges, but they are very interested in analyzing contracts, cases, or even the administrative questions that are many in Italy about public registers and so on. Obviously, one has to explain the meaning of these acts and deeds, but they think I think they are very interested. It is a very good experience. I taught different courses in my life, general courses as private law or specific courses as comparative private law. But I see that the interest of students in this course is very high.
And now another question. I'm wondering what the presenter thinks about the current globalizing environment and how it affects his practice and how law schools should respond to this challenge, like through offering more comparative law.
Yes, I think that comparative law is an essential part of our teaching, but not only in private law. I think in all fields of law, it is impossible to avoid the globalization of law and the matters that even in legal professions affect the way of practicing law. I always suggest students to learn not only English, that is our common language as we see even in this conference, but even another language beyond their mother tongue. Because in all professions, in Italy, in Europe, in all around the world, the problems of globalization are present in everyday work. Even, for example, I practiced as notary when I was young in a small village in northern Italy, and we have many immigrants, many people who came from different countries, and the problem of international private law, for example, was essential. So that I think that another change that we need in civil law schools is to not to confine comparative and international law in specific subjects, in specific teachings, but try to make all our teaching comparative in order to better understand our law and the other legal systems.
And I just want that question was from Professor Neuwirth, and I just wonder, because there obviously is a common theme there, isn't there, between the last two presentations, and that's about cultivating linguistic sensitivity. I mean, do you think that's a fair comment?
Yes. Yes, I appreciated very much the presentation of Professor Neuwirth. I wrote about law and literature, and I think that the problems of language are essential. For example, in the European Union, and I wanted to ask Professor Neuwirth a question. Don't you think that the use of English, we are using English, and English is the common language, I think, of law, is dangerous in modifying legal concepts and legal institutions? So we have this problem in Europe, and how could we challenge this risk?
I don't know. Do I have some moment to reply briefly? Or yeah. Well, yeah, I fully agree with your point also of basically encouraging students to learn as many languages as possible, because each language again provides a different cognitive reality, or like opens a new reality through cognitive changes that come with it. And my hope here is also having read a book called Theorizing the Global Legal Order by, I think, someone called Röben, and they mention the need for a common language, but they don't mean a term like I think a lingua franca, because we know from English too that, you know, like Americans and British are often divided by the use of a common language, and we all have disagreements in our mother tongue and so on. So again, I think that is something that interests me a lot, but I have no answer to that, is to what extent how the future of language will look like after cognitive change, because I think we see already a major transformation in converging opposites into oxymora, but also like shortening a lot of, we use acronyms and emojis and visual information. That's why I think a lot of that will change in the near future. Thank you.
Thank you. Thank you. Thank you.
Means there another commonality between your two presentations, the idea of law as language, so comparative law, not because one legal system might have a different language for addressing the same underlying phenomenon. So is part of what you're both saying that, that comparative law gives you different legal languages to think about the world?
Yes. Yes, I think so. I agree. I mean,
another thing that it seemed to me you were saying there is about acting and simulation. I thought it had two strands to it. Partly, you're saying students should produce different types of output, like clauses or whatever. So that again is kind of stretching people linguistically, isn't it? They're the ones who are producing the language, but they're producing different types of language, maybe a clause or a letter of advice. And so do you think that's important, different types of artifact to produce different types of language?
Yes, I try in my course to make them produce different types. A letter of a lawyer, a clause of a contract. Obviously, we think that students are not able to draft a complex contract, but we help them in trying. Because another I think another defect of teaching, this is in Italian law schools, they are mostly oral, but legal professions are mostly written. And so the first thing that you write in Italy after your exam at the college is the final dissertation. And you don't know how to write clauses, letters to command a sentence. And this is another important thing, to make students write. I think that oral presentation is important. I don't think that tests or just written examinations are enough. But writing is important because the legal profession is mostly in writing.
Another thing you touched on in your talk was the kind of professional liberal. And I think what you were saying is that you don't see them as being separate, but as part of some holistic, part of a holistic education. And I think that if I'm right in thinking that's what you're saying, it seems to me very important, because like you get these tribal battles sometimes between people who say, oh no, nothing in UK law schools anyway. People say anything that reeks of practice, it's taking away from the purity of the liberal law school. And I think you're saying that you take exactly the opposite approach, that you think that kind of liberal and professional all go together in some kind of holistic, humane development.
Yes, I think that we have to think that our aim is cultural, because a law school has a cultural aim. But students, for the most part, will become legal professionals. And so we cannot divide so strictly our teaching from the practical side of law. Moreover, we have to look at the professions, as you said, in a holistic way, because the difficult in Italy is a very strict partition, for example, between judges and attorneys. the state, the Italian Republic, tried to introduce a common legal formation for 1 year, for example, but judges refused it for the most part. And so for the notaries, they have a separate preparation, but most of the students prepare the professions of attorney and notary, or attorney and judges together, so that they try to prepare together, and we have to offer them a common core of the professions, even for not limiting their preparation to the way of passing an exam, because legal professionals need a cultural basis, a strong cultural basis.
Thank you. And one last comment, really, and then we'll move into Bree's talk, from Jean-Michel Morinière. He says, in France, legal studies remain very theoretical because the applied teaching models are unconsciously designed mainly to produce new professors and not to prepare technical professionals. Also, professors never learn about pedagogics and teach as they like or deem fit. This often ends up in reproducing the teaching they've received. Therefore, there's little innovation, and it's difficult to bring innovation.
Well, it is difficult for France, for Italy, but it is difficult for academics. At the beginning of our career, we follow a path, and it is normal because we have professors that we follow. We try to move toward a new way of teaching, but I think that mixing theoretical and practical issues is useful. I know that in France, especially in the first 2 years, teaching is very theoretical. Maybe in France, but I have to speak for my country. In France, the TD should be implemented and should be more practical. But the fact that it is described it is partly unavoidable. We follow a path as teachers, and we have to we have to learn more about pedagogical issues. I agree.
Well, thank you, Professor Cavalaglio.